решил помешать немножко. Объедините, кто
Давайте мы сейчас сделаем. Ничего страшного. Вот эту поставим. Ага.
Большая просьба, занимайте места, пожалуйста, а то мы опаздывать уже начали.
Приветствую. Давно очень не виделись. Здравствуйте, Дмитрий. Видимо, потому что все отрабатываешь.
Добрый вечер.
Good evening. My name is Alexey Kondrashov. I'm an independent expert that many of you have seen working in many consulting companies. We begin this session, which is titled International Taxation in the Period of External Restrictions and Global Information Exchange, Enforcement, or deoffshorization enforcement. We have joining, we have Deputy Minister of Finance of the Russian Federation Ilya Trunin, Dmitry Volvich, Chief of the Directorate of International Relations and Currency Control, Karen Aganyan, Chief of the Directorate of Tax Policy of Gazprom, Viktor Machechin. We'll mostly be discussing the needs of the large businesses, but since we are having an open discussion, I believe we should talk about even other things. In the first row of our discussion, we have Mikhail Orlov, partner KPMG and president of the Expert Council on Tax Legislation of the State Duma for Budget and Taxes, Glubkov, president of the Russian Union of Industrialists and Producers, Viktor Machechin, assistant professor of the Department of Taxes and Taxation of the Finance University of the Russian government. We have many other graduates of this institution. Gennady Kamyshnikov, partner of Deloitte. We also have Sergei Kalinin, deputy of the tax practice of the Legal Bureau, Yegorov, Puginsky, Afanasyev and partners. We have such a representative panel here, and hopefully we'll be able to hear the opinion of large businesses and other relevant stakeholders. I invite all of you to participate as experts, not as consultants, and share your expert opinions. So let's begin. Let's begin with a small poll. I hope all of you know how to use this device. You need to, this application, you need to download the application, you need to get registered and enter the registration code 8644. So put it up on the screen. Actions aimed at forcing to de-offshorize. First, necessary and sufficient. Second, necessary but not sufficient. Third, necessary but excessive. And fourth, not necessary, there needs to be stimulation. Now let's look at the distribution of our votes. And in fact, the sample size is pretty low for this vote. I encourage all of you to participate in this vote so that we have a more representative sample. Well, I actually thought that the distribution of votes will be a little bit different. I don't know why, but I expected a different picture coming out of this vote. In fact, our audience, in fact, favors stimulation, but let's talk about stimulation a little bit later. The first thing that we'd like to figure out is the requirements that the government has set and to what extent the government sees, to what extent the government can say that these requirements actually work, that they are sufficient, that they are adequate, and in what respects is the government going to concretize and improve that legislation. And I believe that we should start with representatives of the government bodies. Ilya Trunin, I believe that I will give the microphone to you first, a representative of the Federal Tax Service, and I would also like to hear what you think about whether these requirements actually work and how they are complied with. Thank you very much for the very interesting question. In fact, the question itself is interesting. Why? Because when we were trying to find the right name for this panel, we found a little provocative name. It says forcing to de-offshorize. In fact, this term, deoffshorization, is pretty new, but our idea was not to outline the totality of the government measures to de-offshorize, to force companies to de-offshorize, or to encourage them to de-offshorize, but to outline what's happening in the world, external restrictions that we call sanctions, and information exchange, and increased transparency and change in tax regimes. That has changed the picture compared to 2012, 2013, 2014, when all these ideas began to be thrown around. So the answer that we don't need to stimulate, that we don't need action, we need more stimulation. What more stimulation do you want? Some of the people present here and in this panel as well are the people that have felt pretty strongly the stimuli, the incentives to de-offshorize that came not so much from the Russian government, but from the governments of foreign countries. So I think we should talk more about what more stimuli do you want, what more incentives do you want. So the subject of our discussion is not so much about the technical aspects of foreign taxation. We have to say that the picture has changed. So we were saying that we want, if we're trying to achieve a situation when Russian shareholders and owners of businesses conduct business in Russia or abroad, they hide behind some foreign structures. They sometimes disclose the structure of their ownership if it's necessary for business or if they like it. Then we got back to a completely reverse situation. These layers began to get exposed due to several factors, and in terms of the new tax and other legislation, we want this return to be even faster than we planned when we started this. Because in fact, we're talking about very big companies, and this process we want this process to be as painless as possible for the taxpayer. So from this point of view, the requirements that you have said or legislative measures that we set turned out sufficient or not sufficient. I believe that more or less they were sufficient, but we can continue discussing this. But I believe the business community will provide its own view about what should be discussed here. I wouldn't even try to find an answer. I would just say that here at this panel we're talking about big business. That's one question. But speaking about small situation, people who are lower or under the big radar, the situation may be completely different. Dmitry Valeryevich, what comments could you offer in terms of administering this process, in terms of how you see the filing of returns, the results that you get, and ultimately the additional tax returns that you may realize as part of this process? Well, I would catch the phrase. I will try to pick up the phrase forcing to deoffshorize. I have been doing this for many years now. I haven't seen any forcing. There are only stimuli, incentives, proposals. So disclosure, this is not a requirement. This is the requirement of all global tax administrations. My second point is that none of that began yesterday. Andrei Vyacheslav just started to say the entire package of all these legislative norms that have been in effect in many other countries when we had the section on transport pricing, very gradually all legislative innovations were accompanied with a 2-year transition period or breaks for the application of fines. In each of these norms, they reflected the mechanism that is already adopted in many countries, that is administered and used in many countries. We didn't invent anything new. Maybe the main points of webs, we kind of went an extra mile, and we fixed this in the tax program. But starting with the transfer pricing and continuing to the concept of the beneficiary owner, continuing to the administration, the reporting. We signed all the necessary conventions with respect to automatic joining. That's the next stage when it comes to exchange. We have implemented this. We are moving towards that, but not very fast. So the adoption period is something that the business has. 7 years. This transition has been extremely gradual. It exists, and it's very clear. But the most important thing that I would like to stress this, we're not talking about the question of forcing. We didn't have this task. We didn't set this goal before ourselves to force everybody to close their offshore companies in whatever jurisdiction they are. these were only incentive like measures. Probably some structures were stripped of their preferences, some of their benefits, but this is a mechanism that every government uses. Speaking about the recent mechanism of deoffshorization, our offshore companies were in the second wave of the tax amnesty, but then again, the norm that really surprises our foreign colleagues. We provide very wide-ranging guarantees. You can return, or you may return, you may not return your assets. If you disclose, you get a package of guarantees and the possibility to protect your rights, to protect your interests. So I believe our main idea is to convince and not to force. All of the mechanisms that I have listed, beginning from the transfer prices all the way to information exchange, the concept of beneficiary owners, these concepts have worked out well because the Federal Tax Service is the administrator. Each draft law and the law were the things that we prepared very well for. We put in place the vision for how to administer the process. You've probably noticed that none of those anti-offshore draft laws, none of them are administered in some hand mode, manual mode. All of the draft laws were very well prepared. We have prepared all the automation means, all of the reporting was submitted and analyzed automatically. So in principle, we tried to make sure that our businesses, small, medium, and physical persons could use easy ways to provide their tax reporting. The only tax form that you have to fill manually is about your foreign assets and accounts. I believe this is a very good comment. I believe international exchange is going to be another method of convincing. Yes, convincing, persuasion. This international experience, this international exchange will probably lead to another wave of those who think hard about returning their capital. So, as they say, God likes Trinity. As they say in Russian, there should be the third wave. Of course, you use very different companies in this work, registered in very different countries. In terms of the requirements that the government presents to disclosure, to reporting, to the provision of information, how sufficient are they? To what extent do they reflect, do they correspond to the situation that exists? I will ask this question to you, and I will ask this question of the Gazprom representative. So Gazprom, get ready. Since you asked the same question of us too, we can take turns answering it. Let me start. Well, first of all, there is this piece of legislation, and it's good. It's good on all counts, on many counts. So it's good for big companies, medium companies. The changing environment requires fundamentally different approaches. We have over 100 companies registered in different countries. Most of them are active companies. They either manufacture, extract, or process materials. There are holding companies, and some of them optimize their taxation regimes. And since this system has gone the full circle, and part of our declaration is to provide the so-called foreign companies declaration. We have done a lot of work. We have destroyed a lot of offshore companies. the requirements for their disclosure, technical requirements seemed excessive to us, so we decided to increase taxation in some countries in the European Union where it was possible. As part of this work, as the so-called Plan B, BEPS, and so on, I believe this was right, and I wanted to say that we took this very seriously. Over 35 persons were hired to prepare this report, and tens of thousands of sheets of documents. We have conducted a really substantial amount of work, and we had the classic question about residency. And in fact, all of the questions that we asked or answered, and I'd like to thank the Ministry of Finance. I'd like to thank Ilya Vячеславович and Alexei Valerievich specifically. Can we control a Bulgarian factory if we create if we have a plan for the group as a whole? So every aspect of the new legislation required us fundamentally different approaches, and now it has been described. We understand that it's an element of internal control. We have some positives. There are, of course, pros and cons. The creation of a new piece of legislation, it opens room for interpretation by lawyers. Lawyers take different issues differently. For example, an important issue for us is the problem of end beneficiary.
Let me give you a simple example. We sponsor Formula One. A Dutch company tells us that they are to receive all the payments, but we are not there alone as sponsors. We were invited by the government by creating this. We paid 30% more taxes. They refused to give us any data about the end of final tax residency. We paid VAT and also tax at the source. Being a conservative company, of course, it creates a lot of issues within. You don't just sponsor Formula One and add 30% to that, but that's the reality. And of course, we want to avoid that. And that's an issue, a question we want to raise to the tax service, to the ministry. What do we do with third parties with whom we cannot make arrangements? We have this circuit. We have Russia, we have the holding and some relations between them. And can these holdings be final beneficiaries? There are some issues that are more at the discretion of the authorities, but we shouldn't be waiting for law enforcement practice, but to pay taxes correctly. Our understanding is to pay at maximum, but if there are any explanations, that would be good. And of course, the last thing, there's an issue about holding legislation. We perform as a holding more and more, primarily for foreign companies, by building our internal control, shareholder control, and the rest. But we receive no support in Russia how we could allocate these costs within the existing legislation. First steps have been taken. They are obviously correct for both big business and individual, private individuals, but at the same time, there are more and more questions that we want answers to before inspectors come to check on us and start interpreting those actions. That's why I keep comparing the first grader with the fifth grader. We did everything and it stopped this year, but the tax inspection have the right to continue to study and interpret, and then they come to us with an inspection with a check 3 or 5 years later. But if we got the same amount of knowledge and information, that would be very useful, because our task is to pay taxes in the best way we can, and most importantly, do it in such a way that we could pay most of our taxes in Russia. We discussed this issue. We have an Austrian holding. Now we have to still deduct 5% in Austria. If we could change the approach here, we could, instead of paying dividends, we could have recovery of the capital that we already invested. And there are still controversial issues about how this recovery or reimbursement will be interpreted. Will it be taxed at 20%, for example? First, I thanked my colleagues here and then presented a number of problems that we need to deal with. And you also entered the field that has to do with stimulating what we need to do to help companies get involved into that more actively. I have a question. Are you part of the tax monitoring program? I am sorry. The point is, we do participate in the tax monitoring program. We have our site in Perm. Starting from July 1st, 2019, we as Lukoil will switch to 100% tax monitoring program. That's what will allow you to get the answers to your questions before you complete your transaction and get all the explanations, and all this ambiguity will disappear. You have a privilege, whether it's by incentive or by force. It's a relatively new institution of interacting with the tax service. That's why we went that way. Most important for us is how do we pay taxes correctly but not overpaying. I will also start by thanking the organizers for giving me this opportunity to speak up, and that's an important issue. It does impact business and the companies who are represented here. Now, let me start by the following. Ilya here mentioned stimuli and how all the incentives are there, and we could add those if those that exist are not enough. And I have my favorite true story that I keep telling at different conferences. It happened in India during the colonial times, when the British troops that were stationed in that country began suffering from poisonous snakes, and there were significant casualties, and the administration decided to deal with this issue. They arranged with the local population and began paying for the population for killed snakes. Pretty soon, there became many more snakes in that territory because the local population began to breed the snakes and sell them to the local administration. There are different types of incentives, and only some of them are right, leading to the desired results. Any changes in the regulatory environment and in taxation for sure should follow this universal formula of carrot and stick. At the same time, when we talk about stimulating deoffshorization, with rare exceptions, in most cases we see more sticks than carrots. And if you don't bring the money into the Russian Federation, you will have to pay taxes. Well, that's a kind of stimulus, but there's another point that is more of a stick than a carrot. It's about increase of admin load on companies. From the point of view of taxation, it's not that critical. Well, you distribute dividends, there's no tax, even though here there are some difficulties as well dealing with Russian accountants reporting and where all these adjustments on. You all understand that. But at the same time, you could avoid that by distributing dividends, but there's also a significant load on your personnel of your accounting divisions and tax divisions. It means that you require additional measures of positive stimulus. Or Alexander began talking about a holding, and let me follow up on that. It's important to understand that in most developed countries, holding companies get special preferences because currently there's this huge global competition for the jurisdictions of presence for specific holding companies. Any jurisdiction is interested in that, and they are trying to provide and offer different preferences so that they could tax revenues or income both in that jurisdiction and elsewhere. It's not only a matter of fiscal monitoring, it also speeds up development of financial infrastructure, certain clusters of the economy, and so on. So for sure, there are many different areas here. It's important to understand that the stimuli to be offered to the government will pay back and bring the government additional benefits of fiscal and non-fiscal nature. As for specific measures of stimulating, let's not reinvent the wheel here. It has been invented already, and this practice exists. Let me give you the simplest example. Taxation at 20% of the capital gain of income of selling shares of foreign companies. This capital gain exists nowhere, or a lion's share of this capital gain is exempt from taxes or not taxed at all. Both about own companies or foreign companies owned by the resident. So when we say that we have this capital gain, if it could be somehow weakened or with some more preferential treatment of that, or totally exempt, that's a totally reasonable discussion with our colleagues from the Ministry of Finance. Today, with regards to Russian companies to get exemption from taxation, they have this period of 5 years of ownership. You could reduce it to 1 year. That would be another productive measure. We looked at some countries that exempt such profit from taxation. Luxembourg, Netherlands, Austria. These are not shadow jurisdictions. They are very respected white jurisdictions, and that's what they do. That would be a good example to follow. Another interesting norm, which is outdated, we have exemption of 20% when they reduce the charter capital of foreign companies. If you get money from reducing foreign companies, it's not taxed, but in that case, with foreign companies, it is taxed. Why such discrimination? It's not quite clear, and it would be the right point for our discussions and formulating a certain position in that respect. Also, from the point of view of dividends, we may look at reducing the share of ownership from 50% to 25% or even less. In Germany, for example, 95% of dividends is exempt from taxes, and then the rest is taxed at 30%. So the the actual rate is 1.5%. That would be interesting to discuss as well. Again, it's the Netherlands, Turkey, Finland, Czechia, Israel. So I can also see some room for maneuvering. There are issues about taxation in the Russian jurisdiction of permanent offices of foreign companies here in Russia, or representative offices. How do you tax them? Or how do you tax foreign representative offices of Russian companies? And to avoid doubt, Russian companies have to create separate legal entities. As a tax director, I'm trying to make ways of moving assets to the Russian Federation, and I face such huge tax consequences of those actions. Here in the Russian Federation, it's hard to offer such options to the leadership with such huge, heavy consequences. Even for such company as Gazprom, you have to pay huge money in the form of taxes, even though we do this good thing, moving assets to the Russian jurisdiction. There are many other items, ambiguity when we deal with charter capital, and where they could make it clear. There are many other items, but my main message has been delivered. We have very specific proposals about the correct stimuli for deoffshorization. If our colleagues would be interested in that somehow, we will be willing to officially introduce them, present them, and discuss them with our colleagues. Thank you. You already moved to the topic of stimulation, and let's do our next voting. Show us item 1200, actions to stimulate deoffshorization. They are enough, they're good enough and efficient, not good enough. You need to extend deadlines and add additional stimuli. They are not good enough. It's too much admin load, and they don't reach their goals. The disclosure risks are too high. If you think any other stimuli or incentives need to be added, do offer them so that Ilya and Alexei could hear the aspirations of business. I really enjoy what you said about branches and representative offices, and I deal with geological surveying companies and mineral extraction companies. You do all your surveying through a branch, because the success there is maximum 20%. If there are any costs, we write them off against the profits of your company, and that's a must. But at the same time, this part of our legislation, from my point of view, as we deal with oil and gas producing companies or those that extract minerals, is not good enough. But even though this work has been started, I don't think the results are too positive. Most think there's too much admin load. Who are those 39 people? I am more interested in those three people who responded positively. We're using cutting-edge technologies. Our speakers, without pushing any buttons, they can give the correct answers to the questions posed. I am interested in those 18 people. Maybe 18 journalists voted like that. I'm not sure. Let's try to comment what was said with regards to those requirements and incentives. And then we will turn to the front row to our experts. And let me ask you one thing. There's one problem from the admin point of view. What you think to be correct? Thank you. I would go back to this term, deoffshorization by force. Remember all those phrases, forced labor or labor by force, and how the ape became a human being, and how an ape began to work, and how labor turned it into a human person. And that we have all these tools for deoffshorization. And as this law was introduced about special economic regions, and we have these enclave tax modes. We have amnesty, we have taxless liquidation, deoffshorization. It would be wrong to say that we were not given the tools to labor, to work. We have to admit that. We will talk about special admin areas separately. I understand that. At the same time, there is competition between employers and jurisdictions in terms of where they have more favorable tax mode. International companies understand this competition, look at it, monitor it, and whether our labor conditions in the Russian Federation are good enough, this question is still open. And the admin load is like your control over your employee. Sometimes to stimulate somebody, they introduce excessive measures of control and administration. Today's costs of administration and disclosure that are too excessive, but that brings us back to the issue of competition. Are you willing to consider this issue and recognize that, yes, it's good to submit so many documents, but if the result is zero, then why do it? I immediately recall the story with domestic transfer pricing.
And this mechanism was deemed possible, for example, for reporting and for even controlled foreign companies. I'm not even sure that all of this information in that needed to be collected to that degree. Well, you've almost answered your own question by giving this example with the transfer pricing. Okay, 2-3 years, 2 or 3 years of practice of new legislation, of the new block of legislative regulations, including the practice of its application by the administrative body. Perhaps the result will be that the decision is made to lower administrative load as an effect. And it can be abolished as an even inefficient instrument. That's a normal story with respect to the the idea that we've heard regarding the load. I believe that we are looking at it from a different angle. I believe that this illusion of a large load, this feeling, not an illusion, but a feeling, and this again brings us back to what I've started with. We didn't have instruments of international taxation. We lived without it for 20-25 years. Okay, 7 years, that's not too fast, but this is not 15 to 20 years that that is needed for the business to adapt, like in other countries. For example, in other countries, businesses are ready and adapted to it, and these novelties don't look like something, or these things, these reporting requirements, do not look like something new for the businesses. So there's nothing to tighten up here. So all of these instruments are already introduced and they're used, and psychologically it's a little bit difficult to move away from it. But I believe, and my finance ministry colleagues have discussed this, and non-innovation can be passed in a unidirectional manner. We try to make balanced amendments. On the one hand, we may introduce some needed for the finances, for the administration, for the fulfillment of certain foreign requirements. We as administrators always try to look for things that are irrelevant, things that may be abolished, that we can get rid of in order to lower the load on the businesses and help them become more competitive in the Russian Federation. That's my personal opinion. That's my answer, and I didn't stop, although I wanted to make a comment. I didn't want to interrupt the speaker, but I want to make a comment. You probably know that there is the tax, there's the income tax, and it had existed before the tax code, and the proposal for changing things that written now in the tax code, it probably makes sense. Well, that's a big plus. That's a big plus for the exchange of experience in this way between the government and the business community. We can make a resolution that the state taxation service supports this proposal. Well, that's very good. I remember during the discussions, 2014, I used to say, cash the taxes until they leave the country. And companies that are residents of foreign nations, they are also subject to the Russian tax code. It should be that way in order to increase our tax collection. That was the time when I actually had this idea, and I didn't raise it, but it's time to kind of revisit it. Now I'd like to move to the first line. Marina Nikolaevna, what are your comments? You represent business here, and you are responsible for the rest of the business that's not represented in this panel. But in fact, I'd like to offer a small correction. The Russian Union of Industrialists and Entrepreneurs is part of this whole system, and Rosneft is not part of this panel, but it's also present here. Okay. According to the good tradition, I'd like to say that back in 2017 we conducted a poll similar to what we're doing now. We asked the companies how they assess the effectiveness of accepted, adopted, and future measures when it comes to deoffshorization. And we learned that 60% of our respondents said adequate and insufficient. This was the highest assessments of the Ministry of Finance. Of course, we can't say that the system makes everybody happy completely, but overall, this system is seen as pretty adequate and good. With respect to the stimulation measures, we discussed with the Finance Ministry some of the measures that I discussed today, and the rules related to the softening of dividends, softening the sale of shares. We hope to receive a positive assessment of the Finance Ministry. We really hope that this is important. This matters, and this is a very good thing for the positive assessment of the jurisdiction that has been mentioned here. Another question that has been mentioned many times here is the question of the full exemption from the criminal liability for these companies that have their jurisdictions in offshore places. We would like this period over the next few years, criminal liability for companies. I mean the leadership of those companies, so that there is no threat of such a liability. The proposal introduced by the Ministry of Finance had to do with kind of a repentance, or active repentance. So we suggest that there should be no criminal liability. I wouldn't like to see a company to face the risk of criminal liability while the tax system is being adjusted. Well, in fact, there is no one to address this question to. And even you, as the representative of the State Duma, the committee is not right. Well, in fact, the Ministry of Finance proposed these amendments or adjustments. I don't think that anyone present here is ready. I don't have any reservations that I don't want to take this question because I don't feel competent enough to deal with it, to address it. I think we'd better punish violators with fines and all sorts of, with a ruble, as they say, but not criminally. Any other comments? No, thank you. Thank you. Well, since we have discussed here many times now, could I give the microphone to Gennady? We're talking about competition between nations, between competition for placing holding companies, special companies in different jurisdictions. But in fact, it's a very big question, at least for me, relative to the entire process taking place in the world. Is there a competition for the tax base, and how is this competition be resolved? Because I honestly think that this is going to create serious difficulties in the dealings between the states. Even though some things are said, each state is going to say, okay, this part of the pie is mine, and this is a very interesting discussion. I believe we are going to get back to it over the next 5 years. Gennady, you probably have something to say. Thank you, Alexei. I'd just like to offer one small observation. For the first time, I've seen such a high-quality panel in several years. I couldn't imagine being in such a panel, on such a panel 5 years ago. Say thank you to the Ministry of Finance. Well, okay, everybody starts with these laudatory words, but 10 years ago, when we talked about international tax competition, everybody said that there's no such thing. But this phenomenon exists now. I would put a different spin on it. Let's open our eyes to the fact that when we discuss foreign taxes, sometimes it seems to us that all the nations have made peace with each other and love each other. But when all nations leave this tax fora, they rewrite their tax laws. They don't care about the BEPS. We know the position of the United States. Their Congress just says We don't care about what other people think is right. We're going to do what we think is right. The United States completely changed their tax system. They introduced, they liberalized their holding. They abolished taxing dividends. What do other countries do? The UK is introducing a tax on the revenues sent outside the country. 25 years if you work as an offshore will take 25, and if you are aggressive in your tax planning. Well, BEPS is not part of that. Australia wrote its GARS, General Anti Violation Rules. And China is doing the same thing. Well, in fact, we do have a thing or two, but we don't. But we could do more. We're not against the taxpayer. We are so fixated on punishing everybody for violating. Just like in the example with Formula One, Russia doesn't have its own national strategy for fighting for the tax base, and half of this strategy has to target violations in. I don't think that Lukoil should be punished for sponsoring Formula One. Well, Lukoil didn't have enough information about who stood behind that company. We are fighting aviation leasing. I don't have such a client, but I know for sure that this happened. So international banks are ready to provide funding for international planes, aircraft, on the condition that you park it in certain companies, preferably in Ireland. Not on none other conditions will you ever get these breaks. Of course, these are the requirements of the bankers. These are the requirements of the bankers. I'm not trying to attack the tax administration. We did the right thing when we wrote that article about the taxes. It should exist, but it should be seen as an instrument of fighting tax violations, tax irregularities. We need to take a different look at it. What's happening now? We are moving away from the OECD tax model to the UN tax model, and we kind of shoot ourselves in the hand, as we discussed in the. We discussed this. Me and my colleague, we discussed this, and this seems like we're fighting ourselves. It seems as though somebody is trying to really violate the international tax law. And the second part, and here I would like to, not repeat myself. We need to fight for the tax bill. We have to bring them in. I will add. In the Netherlands, they redistribute the dividends from the tax source. With respect to the fight for the fiscal persons, we have done nothing in that regard. Now, the fight for the tax base should be more active. We have to fight for the taxpayer until they self-organize in some other jurisdictions. Of course, we have companies that are the national heritage. But other companies, when they make the decision of where to create a holding, they eye the United States with great interest, with all the problems that exist, because the tax system is very well tuned there and for the market. And the holding is what the things described in SARS. We need to fight for the taxpayer. Another small element that I would like to mention, and this is a trend that we've seen for a while, there is a description of how this has taken place over the years. So we have agreed that the tax system should be neutral. 10 years ago, this really wasn't received very well. How can a tax system be impartial? So what's happened in other countries? In the EU, there's an official document, a review that came out last week. The EU is concerned about the competition between capital investments and credit investments. Companies want to invest in companies are more interested in investing in credit. They get a lot of breaks. In fact, 4 countries have introduced tax breaks for capital investments. If you invest in capital, so they can, so that allows you to bring down your tax rate. That's a neutral way of influencing the choice between the investing in capital and in credit. But when we look at companies, at how companies will invest in European countries, and at least holdings, they will be put in there not credit, but they will be invested into capital for holdings. They will be investing money into capital. So in terms of settlement saldo, money will be leaving there. And in fact, 4 countries already do that, and we have to constantly look, and we have to constantly monitor this real war for the tax base that is going on in the world. And I know when you meet, I talk to you as officials. When you meet between yourselves, you are of course good friends, and you're one of the few ministries that still keep friendship with foreigners, and this was very clear yesterday. But in our national strategies, we have to be clear that when you come back to Russia, you have to know what they do against us and how we can protect our national interests against what's going on in the world. That's the structure. Well, thank you very much. I believe that was an extremely interesting intervention. Well, at least that provides some food for thought. Well, let's, Mikhail Yurovich, out of these proposals that you've heard, or your own proposals, what proposals would you try to discuss at the next expert council? I believe that the problem that the tax system is facing, it's very hard. Problems are hard to discuss at an expert council. I'd like to reinforce what Gennady has said, meaning that we sometimes very blindly copy what is done in the West. Sometimes even the State Department doesn't have to do anything, just to drop some information on us, for example, about some taxes of Titan, and then again we're just going to blindly copy it, and no sanctions will be needed. But I'm not going to say that. We need to shape our national strategy when it comes to deoffshorization. Over the past years, we have learned to work with these laws, and we read them differently. We understand this philosophy, and I think it's come time for us to meaningfully understand these pieces of legislation and correct our past mistakes. But here's what I'm afraid of. Our legislation is not worse than foreign legislation when it comes to deoffshorization, and I'm saying this. I know what I'm saying because I talk to other people. I talk to other people. I say that, okay, I know about your law. We have similar law, and they sometimes write down into their notebooks our experience. But here's what our problem is: our business needs predictability. This is what other people have said here. Predictability, even if the rules are harsh, they should be immutable. We live in conditions of unpredictable past. And the problem is not the fast change in legislation, and I don't think that anyone in May could envision what kind of legislation will happen several months down the line. But that's not the question. The question is that we start to freely interpret the spirit of law instead of reading the letter of the law. We begin to absolutize and we begin to use it for good reason and for no good reason. We try to find the law where it's... So if it says 2 by 2 equals 4, we try to interpret it saying that maybe 2 by 2 equals 5. So I guess my idea is that the rules that exist today will continue to exist tomorrow. Several examples. We very often see in letters from authorities different, sometimes frivolous interpretations of the law. For example, a letter from the Federal Tax Service explaining that we have not been doing the right thing, and it means that we need to correct our risk policies and so on and so forth. Again, they find some spirit of law. Second of all, if we're talking about deoffshorization laws, when you wrote Article 7, which deals with the real recipient of profit, beneficiary, I thought there were only 3 types: interest rates, dividends, and royalties. And I thought that the Ministry of Finance knew this. And the original article was dealing with those types. But in fact, it turns out now that the international transportation and international leasing is also can be construed as a source of income. And again, other cases also exist.
Like this law on international holding company uses the term that the lower rate is used regardless of the dividends or double taxation agreements, and the beneficiary is there who is the actual receiver of profit. But this practice, I think, is justified and is now widely used in our legislation. Before we finish the law, complete the law, and trying to correct mistakes, we need to think about where we want to be. Do we want to get money to close some gap in the budget? That's not a problem. We could reinterpret everything in such a way that everyone pays a lot of money. But do we need that? No. We want to set up some strict rules, but they need to be stable so that we all use them and we're all sure that they won't change in 5 years. Unfortunately, monitoring doesn't guarantee that 5 years later the new leadership of Federal Tax Service won't say that now they interpret the law differently. Well, these are the issues of law enforcement and how to interpret that and whether the courts are active or not. And since I'm sure our other colleague also has from Sergei Kalinin, let me give him the floor. I will continue along the same lines. I believe that the law enforcer began to use this term too broadly. We have these opposing opposite trends. We have this position of OECD and comments to model convention in the version of 2014, then talk about narrowing this term, beneficiary owner or actual right for the profit. It says that this concept is only used when it's obvious that the beneficiary has this legal obligation to pass this profit further. It's used about the agent, the other persons who have this contractual obligation, no more than that. And then the existing version, it says that, but if there's abuse, then other articles are applicable. Article 29, talking about abuse. They also have national legislation. They have general provisions about this double taxation avoidance agreements that should not lead to total avoidance of taxation. And this beneficiary owner simply shows who receives the income. And in this case, it's the resident, someone who has no contractual or legal obligation to transfer this income further. That's the comment of the OECD. That's in the Russian national legislation. We have a similar wording. The tax code uses the same notions. It also says that if there's no right for this income for this for the first beneficiary, they cannot claim the privileges according to the international agreement. But in April, we got this letter from the tax service where they considered this beneficiary owner concept. And in the first lines, we see that this is exactly that a special case of unjustified tax benefit, which is where they're trying to fight this abuse, and using the criteria for that unjustified tax benefit is what they believe they need to consider first when they decide whether this person has the rights for privileges according to the contract. We look at the business goal of the transaction. Could we requalify those transactions? Maybe the economic purpose of those is different from what we have on paper, but that would be half the problem, because in general the OECD and the national legislation, nobody says that this abuse is there, but if there's no business goal, then this privilege should not be used. But the cancellation should be based not on the fact that this person is not the beneficiary, but rather based on special provisions on limitations of privileges in international agreements. But further on, this letter says something else. It mentions another criteria. It says that if such beneficiary is not involved in active business or entrepreneurship activity, he loses the right for privileges according to this international agreement. And there are specific cases. For example, if a company deals exclusively with financing or funding, getting profit from financing within the group, if it gets income from investment into subsidiaries, and or provides only consulting services, there's a whole list of passive incomes. It automatically the company automatically loses this right to use privileges according to the international agreement. Let me quote from this April letter. It's let's not quote it. We will go too deeply into the details. I won't even ask for comments from the Federal Tax Service. It's a topic for the conversation, at least to sit down at the negotiation table. That's the third speaker in a row. Let me make a comment immediately. We have some colleagues here from some universities, those who train students for us for international taxation. For 3 years in a row, we have this Italian professor who delivers lectures specializing into those norms at the MLI. And during the last lecture, I was present there. He speaks at our taxation. He spoke exactly the opposite to what you're saying. When MLI began to get formed, the approach to the beneficiary owner, I'm not sure what was there in 2014, but in 2016, 2017, leading theoretical experts in the OECD, they were interpreting it through the norms that have to do with anti-avoidance norms. You quote the letter instead of looking at the entire set of documents. The criteria exist, and there can be any instruction or letter or law or court decision. If you withdraw one line and say look at this line, it's misinterpreted. You will probably be right. But in general, and we never avoided this principle, it's a set of evidence. In 54.1, it says no formal approaches, no formal errors or problems could be interpreted as a violation, only as a selection of evidence, a set of evidence. And it's not to close this discussion, but maybe to rather open this discussion and look at it not how OECD understood it in 2014, but according to the latest years when they began to implement it. And even the authors of those concepts who said 10 years ago one thing, the same people talk about somewhat broader concepts, and they think it's a big victory for them that those provisions were added to those anti-avoidance norms and not interpreted separately. It's good that you ask this question. Of course, this discussion deserves to be continued, but just there are things to discuss here, and you cannot say that something is wrong here. It would be incorrect. But law enforcement practice is being generated. We learn to use new articles on this law, and they forgot to say that it's about passive income and how to interpret that. That's the price of that word, especially something that it says in the legislation. I'm going to give the floor in a certain order just because we have time limitations. There's this issue about the actual right for income and its interpretation. It's most critical this year, probably, in this area. There was this very interesting discussion now. Of course, you can refer to different concepts of actual law, but what should be the main criteria when we make any decisions by tax authorities? Is there abuse or trying to avoid taxation? If that factor is present, all the evidence and circumstances point to that, perhaps you need to more stricter rules than those that you read about in the Federal Taxation Service letter. If there are formal signs, but if there was no plan to do that, or then, and if you may agree with that on the one hand, but there's another issue that we cannot resolve for many years in the tax legislation. I'm not sure when it will be resolved. It's a qualified judgment, and how much freedom of interpretation you can give to tax authorities. In international taxation, this problem appeared fully. Transfer pricing, actual right for income, and so on. I cannot say let's remove it here and add passive income there, and it will all be settled. They were not mentioned there just in case, because they thought that what if we forget something and then it will be harder to amend things. Let's write as it is, and then we'll see how it is going to work. Let me add something here and then give the floor to Marina. And when we talk about the actual right for income, we don't look like, in the case of Formula One, but the entire chain, because I am concerned about cases when, due to different reasons and historic reasons, we have chains that go from Russian assets through foreign companies to Russian assets and to Russian holding, and to break this chain is too hard. It would be good to deal with it, but it would require too many taxes, but it's wrong to feed foreign jurisdictions. It would be wrong to create such a system that would force a company, for example, intercompany finance company, to put 150 Swiss specialists that are the most expensive employees ever. And we should not feed foreign jurisdictions. And here's this end-to-end ownership. Do you have anything to add? Colleagues, let me start by saying that we need to get back to the results of our poll. Deoffshorization law seems to be written well by good professional authors, but the poll shows that the incentives do not work well. Why? To believe in these norms, you need predictability and some kind of practice of trust. You used it, it was not challenged. And a few things here. First of all, we need to understand the doctrine of how we use the anti-avoidance law, because they added too many additional things into this right for income concept. For example, the company buys out shares, but it turns out this is paying dividends, and the Vedomosti newspaper publishes that, and there are these public stories of buyouts. The same with leasing, when there is a scheme, when there is no actual receiver or beneficiary, and the Russian airlines have to pay taxes. There are examples like that. There are special topics there. If you want to qualify in a certain way, let's do it through the code. In many legislative systems, there are special anti-abuse laws. If we want to subdivide these capitals, for example, there's not enough capitalization. If you want to say something else, let's do it, and not say your debt looks like capital, or maybe not. And how you play it, how we plan it, we have to play this guess the tune game. And let me add a few other ideas that are quite popular, and we would like to develop them further and use them. Alexis said what we call end-to-end approach. This is the situation when we admit that in the chain of foreign companies, they are not the actual beneficiaries. A Russian person is good. It's good for the budget. Instead of 5%, in most cases, we pay 13%, and that's quite a lot of money. But give us the guarantee. It's strange that that person abandoned their actual right, and let's take another 15%, and then maybe more and more. But when we can get 43 instead of 13, we'd better send people to Cyprus and continue paying 5%. This is a very painful situation. This is something that came to us from the trend about buyouts of large companies. It is still there. In my opinion, this is one of the most important items, to disregard the companies that don't exist in reality, or you can make it as if they just intermediaries, and you cannot liquidate them because we will have to pay huge taxes elsewhere and hire someone else. I hope that you can deal with some of the key issues by using some of those amendments. There's another tool that started to work well. That's taxless liquidation, but it's a paradox. Those who were interested in that, they were trying to do it. People kept saying, there's not enough time, let's wait, maybe they will announce that again. And I say, maybe we can turn it into a permanent date to avoid erosion of bases in foreign jurisdictions. But why don't we keep this pretty good instrument which really works and really stimulates business to return the activities into the Russian jurisdiction? And finally, we have this new rule about independent recognition of tax residence for Russian companies. In the first years, it was really hard and scary. What if they recognize us as residents for previous periods? But there was a wave of companies that are moving to this new regime, and to make this wave bigger, I can only repeat what colleagues said. Yes, we need to improve the Russian holding regime in terms of dividends and capital gains. It would be good to work further on taxation of foreign branches, and in general you can look at foreign practice, what other attributes there are of a good holding regime, so we could be comparable with jurisdictions which we look at in terms of international tax planning. We still have our third question of our poll. Let's try voting. If you want to be a Russian residence domicile. All right. Establishment of special admin districts is mainly aimed at further stimulating deoffshorization, development of remote territories, and solving specific problems of specific companies. I needed to introduce the company in this way. That's why I chose that particular mode. Even though it makes sense if you recognized your residency. I don't want to spend too much time talking about it. We have neither the law nor law enforcement practice. The law has been passed in first reading. You got me confused as I was preparing for this discussion.
Interesting. 3 votes. Magic number. Is there a law on the law application practice? No. Okay, any difference between question 1 and question 2? I think you can answer yes to each one of the 3 questions and still be correct. You know where I took those questions from? You won't believe it. Question 1, 2, 3. The questions on the website of the Ministry of Economic Development. Vladimir, since you believe that enforcement or forcing play this role, very briefly and generally, to what extent do you see that this mechanism is necessary and possible, no matter what it's used? I would be interested to. It would be interesting for me to analyze this document in terms of jurisdictions, how they stack against other jurisdictions. Let's remember what tax breaks do we have. The first tax break is 1 year ownership, and 0% is applied to shares sold for 1 year. This is for holding companies that we have discussed that they can that which is not like European countries. In European, there are thresholds between 10% and 30%, and in fact, many already use this benefit. Either sanctioned companies that have to lower their dividends or increase it. And in developed countries such as France, Poland, and others, they apply 0. There is a lot of room for improving competition. This is not about forcing companies, this is providing incentives. So these companies are incentivized to transfer to Russia. This instrument wasn't present, now it's present. That's the first thing that the law makes possible. That's a very good thing. And we are going to introduce similar changes like that, similar changes. From this point of view, through this critical prism, was this law looked. We are not making the regime better than in developed tax jurisdictions. We are creating equally favorable conditions that make it possible for companies to redomicile, to move to Russia. And the second thing very interesting in this law, and that we pay 5% to dividends to foreign companies, foreign domiciled companies. What are we talking about? We know the example about circulating bonds. This discussion, I think, we had in 2012, 6 years ago. We couldn't use 20% on coupon because we have jurisdictions that use 0, and in practice it's very difficult if you have a lot of private investors the right to income. We have different mechanisms, but they didn't prove the right. They didn't have the right to prove this income. And again, we have the same problem. If a company exists in Cyprus or Ireland, there are even different jurisdictions that completely abolish this tax. Cyprus, for example, allows the companies to not pay any tax. So if a company moves back to Russia, then we have to somehow incentivize these companies. How do we make sure that this mechanism is as good as in foreign jurisdictions? We set the rate at 5%. Public company was paid to offset the tax costs incurred by the company, and this is good. This ties very nicely to whether this is capital or debt, and if we have the possibility to, if we have the ability to invite foreign companies, and if we don't have the ability to attract companies, we can use Russian public companies. The Russian public companies would be more incentivized to circulate and place their bonds in Russian markets. And again, many markets in the West will be closed. And then again, Asian markets are very welcoming. So what do? Many countries such as Hong Kong, Singapore, tax dividends at a rate of 0%. We have some HNWI individuals, high net worth individuals. They have domiciles in Switzerland. They get dividends at 0. Yeah. So it's a question of investment. How their incomes will be taxed. So 5% is a mechanism of balancing. If we introduce the institute of redomiciliation, it's a two-way thing, and you can go back. We should support this competition. This is a very interesting approach because it allows us to get our rules in line with best practices. What other things do we have that could be in this law? Some things that in fact raise questions on top of technical things. If we begin to analyze what they have, what we have the question of exchange rate differences, and it not only affects foreign companies. Some companies redomicile. All of us think that the ruble's exchange rate is not reflecting the reality in 2, 3. The ruble may get devalued or appreciate, for example, and this is another factor. This is another factor that has to be taken into account. Can this be an element of an accounting policy? This is an interesting question. This is a topic that may be very interesting for companies that have a large debt denominated in foreign currencies. Article 275.3, it not only concerns redomiciled companies that are voluntary tax residents. How do we determine the tax base if they come back to Russia? Okay, we can look at the shares. This is accumulated but not realized profit. It shouldn't be taxed in Russia. So, companies redomiciled before March 1st to the amnesty, only these companies will be able to have non-realized profits. For example, if they do not meet the criteria for the 0% interest rate, they will be able to get the profits and not pay taxes on the profits that they have received before. In many countries, in the case of redomiciliation, capital gains get obtained in redomiciliation, but in the incoming redomiciliation, the tax basis is determined at the time of entry, because redomiciliation is like sales and purchase, like a sale and purchase. So a critical analysis of the competition of Russia and foreign jurisdiction, this approach to assessing the, and I would like to thank the Ministry of Finance. If we continue, and I completely agree with you, I believe if we look at this matter from the terms, in terms of competition, this would be a very good, let's call this panel international panel for international taxation, and words of thanks for the Finance Ministry. Comments from the Finance Ministry. If it's necessary, I actually have something to say, but Ilya maybe wants to add something. Please, I have one last question to Victor. I think is the most important, so please be quick. Well, the Federal Tax Service hasn't read the law yet. A Federal Tax Service believes that the law has gone through the first reading. There's still things to work on. Pay attention to the name, Special Administrative District. So if you remember, there are certain administrative districts. Hong Kong, it uses the principle of one country, two systems. So we worked on the same principle. There are instruments that have to be implemented, but not throughout the territory, but in a certain geographic location. And this is not a single example, but are there any cases of anyone redomiciliating? Okay, I don't know if we have to wait until March. In the morning I met my Kaliningrad-based colleagues. They have a little bit different problems. They don't have the island of Oktyabrski. This geographic landmark doesn't exist. Nobody knows where it is. As you know, foreign companies, I don't know if island Ruski exists in the register of objects. We will run these pilot projects together. 2 comments from Gazprom and from Lukoil too. And the main question that I would like to leave time for. Very short comment. We looked at the law on special regions. It has some things that we would like to improve, but in fact there is one thing that really makes its use complicated. Redomiciliation, in fact, means liquidating the company in the foreign jurisdiction and re-establishing the company in the Russian jurisdiction. Some tax systems, including in Germany, tax companies that exit. If we want to redomicile a company in the Russian Federation and liquidate a company in some jurisdiction, then unfortunately in this foreign jurisdiction you have to pay a significant tax. This is a certain share of its market value, and this makes the redomiciliation process much more expensive. If we could, for example, arrange some procedures to minimize the taxes that go to the budget of a foreign government. Okay, we're not going to redomicile Gazprom to Stadion Kristovsky. It's a stadium in St. Petersburg. This was a joke. Okay, now let's give the floor to the sponsor of Spartak. Important question about the exchange rate differences, especially for physical persons. This is a colossal thing. The Russian Federation, in terms of taxation and instruments, passive instruments, asset management, trusts, makes it impossible to work with these instruments abroad, because not only the result is taxed, but the exchange rate difference. The Russian legislation, because the legislation is not synchronized, 20% of $1.02 is taxed at the rate of 20%. So that's a lot. That creates a colossal problem for investing into Russia, because, for example, an investor invests $1 billion, builds a foundation, and then he gets a reassessment from 60 to 69. He hasn't done anything, he only has the foundation, and then again he has to pay the tax, income tax. The same thing happens with those who hold credit. So that creates a huge disproportion. I think we have to revisit the issue of currency exchange rates, or, for example, we're talking about exploration and development of oil fields. We start drilling, we haven't produced anything, we haven't found anything, but we already start to pay taxes. The regions will be asking you about it. The regions will pay 17% of tax at a rate of 17%. But when there is a reverse exchange rate difference and they don't have any money to pay teachers or doctors, so in fact the stabilization would allow the taxation of realized exchange rate difference. That would increase stability. And one last question. I actually thought, who is going to draw conclusions? Usually this honor is given to the government bodies. Now we're going to give this opportunity to the academia. What are you going to tell students, Victor, when you go back to your school? I move here so that everybody can hear me or see me. I don't mind. I don't mind the fact that I'm the last to speak. This is more of a privilege. I'd like to say a few interesting things to you. Two parts. What's happening here, and second, what's happening, in other words, how it looks against the background of what's taking place in the world in the international taxation. And I will tie this into education and science, because these things are closely related. First of all, I would like to say that we do have science. I remember two young PhD students, Ashot Rakelov and myself, 20 years ago. We worked for a while, and we wrote a paper about the factual right to profit. We hoped that somebody would read this paper, and things have changed since then, and I have monitored the changes. Interesting conclusions can be made. I will not go into detail, but very briefly, the discussions that we've had, this background does not allow finding the difficult. I didn't even hear the categories that need to be researched in order to find. Unfortunately, currently, there is a lot of literature out there, a lot of information that allows us to see where the problem lies. But I'm moving on. Science exists, and there's going to be a big conference, less than 6 days, international, in English. We invite high-profile scientists from around the world to help us discuss the issues of taxation at a higher level. But today's discussion, if my colleagues and practitioners and academicians came to listen to this, they would be surprised. They would be surprised how everybody, panelists and those in the audience, in the front row, how they got together, because the conversation was about very different questions and very hard to explain how these things got in one place.
We are not surprised. We are used to that. But those with critical thinking that say, you're talking about totally different things, let me try to explain why. These are really different things. As if you're my students. With students, you have to be cynical and quick, and you have to give them a system. You cannot just say, read the code and you will understand everything. Taxation consists of 3 groups of rules. Taxation itself, subject-object, who is going to pay how much, according to which procedure. Then tax management, information exchange, registration, response to answers, and then fighting avoidance. Historically, in our country, most of the questions were developing in the area of fighting avoidance, but not how to pay taxes correctly. We were fighting something. From the point of view of tax management, that's the simplest thing. And here we have some serious progress, and we are the leaders here. We sign different conventions, but these are technical issues that don't directly impact taxation. This is what helps you calculate the tax. But the most important territory is the territory of who should pay how much. And for international taxation, it should be very clear. Unfortunately, it's not done with us. If we look at Chapter 25, we will see the main rules there. They are born based on the instruction 34 and so on. And then this chapter developed when problems appeared. Ilya and others remember the situation with Eurobonds. This fire was extinguished. And then offshorization, deoffshorization, that was another fire against the background of latest dramatic years. The courts made a lot of decision fighting the deviation from the court position, and we are in a vicious circle. When there's no logical position and solid position on national taxation, we have to deal with all these painful issues. We need to get back to what the President suggested, to fine-tune, regulate, improve the rules that we already have, and we need to have them in certain sequence to present them in the legislation. And now what's happening abroad? Here I support Gennady Kamyshnikov, who said that every country protects their own tax base. And if we look at this project, it's not what our colleagues think about, and they may be surprised about what I have to say. When they announced that particular plan in St. Petersburg, we were in charge of that process, but did anybody read what it said? It said that countries that require additional budget financing begin to fight with the wrong use of international rules, and it endangers international tax order. That may lead to chaos. That's why it's there to synchronize the activities of different countries and to limit the activities of those countries. And that's why this is the instrument that limits us, really. What is happening in the OECD is the fight of different countries to protect their taxation base. Which one is going to be for Russian companies? What we need to do with real foreign investments? Perhaps there will be some other rules, and when we will get this sequence, it will be easier to talk to taxpayers, fight deviations, and get integrated into the global system. And the final thing is what's going to be a revelation to you. The Russian Federation has good traditions in international taxation. The Russian Empire was the first country that signed the first double taxation agreement. We run out of time. Thank you for this interesting session. And those who will come after us, they will be trained better and be passing better laws and administer them better. Thank you very much.